Hello, and welcome to the Sentencing Guidelines Training New Practitioners Introduction to the Guidelines. This training will offer new practitioners an introductory overview of the guidelines as they pertain to a single basic offense. This is broken into 7 modules. Those modules are the Sentencing Guidelines Grid, when is a worksheet required, Severity Level Overview, using the level of sentence for criminal history calculation, criminal history calculation in 4 parts, using non-Minnesota offenses in criminal history, and finding the presumptive guideline sentence. Just to clarify, a basic offense means this training will not cover more advanced topics, such as enhanced offenses, offenses with sentence modifiers or mandatory minimums, or calculating criminal history for multiple offenses sentenced at the same time. As of August 1st, 2016, there are 3 sentencing grids. The grid that is used to find the presumptive sentence is based on the current offense being sentenced. This is the standard sentencing grid, which is used for any offense not found on the sex offender grid or the drug offender grid. When using any grid, the vertical axis shows the severity level of the current conviction offense. Usually, the offenses reflected on this axis are examples of the most common types of offenses found at the severity level. More detailed lists of severity levels can be found in Section 5A and 5B of the guidelines. The horizontal axis shows the criminal history score that has been calculated from the application of guidelines policies. Where those two meet is the presumptive sentence. Each cell on the grid represents 2 components: the presumptive disposition, which is either stayed, which is the shaded cell, or the non-shaded cells, which show a commit to prison sentences. The presumptive duration is also reflected, and the length of those sentences are shown in months. In the non-shaded areas of the grid, a prison sentence is shown with a duration that includes a 15% decrease and 20% increase, known as the lower and upper range. This allows the court to impose a sentence more or less than the presumptive sentence, also sometimes referred to as the middle of the box, without a departure. The sex offender grid went into effect for specific offenses committed on or after August 1st of 2006. This grid follows the same principle as the standard sentencing grid for determining the sentence, disposition, and duration. The drug offender grid went into effect for specific offenses committed on or after August 1st of 2016. This grid also follows the same principles as the standard sentencing grid and the sex offender grid for determining sentence, disposition, and duration. Training Module 2 will cover when a worksheet is required to be completed. Now, although an offender may receive multiple convictions, that does not necessarily mean that there will be multiple worksheets completed. Only those offenses which receive an imposed sentence or a stay of imposition will have a sentencing worksheet submitted to MSGC. Complete a sentencing worksheet if the offender will receive a stay of imposition, a stay of execution, or a prison sentence known as a commit to the commissioner or an executed sentence. Worksheets for non-conviction dispositions, such as stays of adjudication or continuance for dismissal, can be completed and placed on stay of adjudication hold in the EWS system. These worksheets should never be submitted for review unless the non-conviction disposition is revoked and a sentence is imposed. When a plea agreement is negotiated for a felony level conviction, and the sentence will be 1 year or less, 365 days, the offense becomes a gross misdemeanor. The most common situation for this type of plea agreement occurs when the offense cannot be amended to a misdemeanor or gross misdemeanor level without changing the offense altogether. For example, a terroristic threat, now known as threats of violence, is an offense with only a felony level. Therefore, to amend the charge to a misdemeanor or gross misdemeanor level offense, the prosecutor must amend the charge to a completely different offense, such as disorderly conduct. If the prosecutor wants the offense to remain at the felony level for conviction purposes, but will accept a sentence at the misdemeanor or gross misdemeanor level, this is a departure. MSGC requires a worksheet so that when sentencing data is received, we can record the departure appropriately in data. Now, if the prosecutor amends the original charge of threats of violence to, let's say, disorderly conduct, which is a misdemeanor, then no worksheet is needed. This is because the offender was convicted of a misdemeanor, as opposed to being convicted of a felony, but sentenced as a misdemeanor or gross misdemeanor. Now, this is called the level of sentence when we talk about convictions being sentenced below the offense level. We're going to cover that in Module 4, and we'll explain much more about how this duration that gets imposed for sentences determines where the offense goes in criminal history. If you're trying to determine if a worksheet should be completed for an offense, it's helpful to look for two things. Does MNCIS, or Odyssey, as we see here on the screen, or MGA, indicate that the conviction was a felony? And secondly, does the level of sentence contain the statement, conviction deemed a either gross misdemeanor or misdemeanor, pursuant to 609.13, and you can see that statement at the very bottom of this MNCIS slide on your screen. There we go. If both of these indicators are present, then the offense was a felony sentenced as a misdemeanor or gross misdemeanor, and a worksheet must be submitted to MSGC. For Module 3, we're going to take a look at severity levels. Nearly all felony offenses are assigned a severity level ranking by the Commission. The severity level is one component on the grid, which is used to determine the presumptive sentence. This section will help you navigate the severity level tables found in Section 5A and 5B of the Sentencing Guidelines. When reading a statute, always move from left to right. Here, we are using a drug offense as our example statute. So reading left to right, we see 152 as the chapter and then 023 as the section. Additionally, the statute would contain a subdivision and clauses, perhaps. But for some offenses, the Commission ranked the offense based only on the chapter and the section. This is true for many controlled substance offenses. In this case, just look for the chapter and the section to find the ranking. Whether it was sale or possession, meth or marijuana, those elements didn't factor in to the ranking decision. So here we see a controlled substance in the third degree. And whether it's sale or possession, any drug, any amount, all of those offenses are going to be ranked at severity level D6. Now, when you're searching for a severity level on the table, you want to make certain to pay attention to when the offense has multiple severity levels. In those instances, be certain to pick the severity level which corresponds with the subdivision and clause on the complaint, as different clauses have different severity levels. So in this example, we're trying to find a severity level for a criminal sexual conduct in the second degree under MinStat 609343 subdivision 1, parent C. We don't want to just select the severity level for the first offense we come to under 609343 because that doesn't correspond to the conviction statute. If we keep searching right below that, we'll see that that conviction statute falls under the severity level of B. For some offenses, especially those that are monetary in nature, the Commission set the severity level based on the monetary amount of the crime. Oftentimes, that information is found in the penalty statute. If that doesn't get pulled into the worksheet through MinSys, you may need to dig further into the complaint to find it. Also, if no penalty statute is listed, the monetary amount of the crime may be given in another location. In that case, find the chapter and the section of the statute on the severity level table and select the one for the amount. Remember, it is the monetary amount of the crime, not fines or restitution, that is used for the ranking. So in this example, if we didn't have a penalty statute, but we knew the amount of the forged check was $2,300, we could find the severity level by locating the check forgery section of the table using the chapter 609 and the section 631. Then find the amount that corresponds with the amount of the offense. In this case, it would be a severity level 2 under subdivision 4, parent 3, parent A, which is check forgery 251 to 2,500. Theft and theft-related offenses found in Section 7 on the theft offense list will use the penalty statute to assign the ranking, since that's where the amount of the property is valued. These offenses will be ranked at either a severity level 2 or a severity level 3. Now, it's important to note that while the penalty statute plays an important role in determining the severity level for these offenses, some of those statutes apply to other offenses with other severity levels. Take, for example, the penalty statute of 60952 subdivision 3, parent 2. Here we see that for theft and theft-related offenses on this table, the statute tells us the amount of the offense was over $5,000. But this statute also includes theft of a trade secret, theft of an explosive or incendiary device, and theft of a controlled substance, none of which is ranked at severity level 3. So, when the penalty statute is 60952 3 parent 2, ask this question: what was the property stolen? If it is not one of those that we just listed, trade secret, explosive device, controlled substance, then it should be ranked at the amount of the property loss, which would be a 3. So, a suggestion here: flag the offense list in the guidelines as a quick reference for monetary offenses. Module 4 will cover using the level of sentence for criminal history calculation. The level of sentence is going to explain how the imposed sentence duration or potential lack of imposed sentence duration will affect how an offense will be used in criminal history. The level of sentence is an important component in determining where an offense belongs in criminal history. In Minnesota, the level of sentence is determined by the duration of the sentence imposed by the court. This is true regardless of the conviction offense level. In order for a felony, conviction to be considered a felony prior for criminal history purposes, a sentence of more than 1 year must be imposed. That's where the minimum sentence of 1 year and 1 day comes from. But the court can impose a sentence below the offense level under MnStat 609.13. Think back on the non-felony sentence slide in Module 2. This example showed a felony conviction for threats of violence that received an imposed sentence of 365 days. That imposed duration changed that felony conviction to a gross misdemeanor because 365 fits within the gross misdemeanor parameters. Pay close attention to the duration of the sentence imposed, either executed or stayed, by the court, as this will help determine where an offense belongs in criminal history. When an offender has their sentence executed, it will appear in Mensis or MGA as either commit to the commissioner when it is more than 1 year, or as local confinement when it's a misdemeanor or gross misdemeanor sentence. These offenses are usually very straightforward, as you will have an imposed sentence duration that corresponds to 609.02, subdivision 2, 3, or 4. When an offender receives a stay of execution, a term of prison or local confinement will be imposed and then stayed for a specified period of time. Additionally, the offender may receive local jail time as a condition of probation, known as conditional confinement. A major component of this sentence, aside from the imposed duration under 609.02, is that there is a recording of a finding of guilt by the court, which means there is a conviction. When imposition of a sentence occurs, a conviction must first exist before a sentence can be imposed. When defining the level of sentence, the key element of this type of disposition, a stay of execution, is that there will be an imposed sentence which aligns with the duration found in MnStat 609.02, subdivision 2, 3, or 4. It will be that duration that defines how the offense is used in criminal history, as opposed to the conviction level, the probation term, or the conditional confinement pronouncement. This slide demonstrates how a felony level conviction with an imposed sentence duration that falls below the offense level will be treated under the level of sentence. Even though this offender pled guilty to a felony threats of violence offense, a sentence of 365 days was imposed. It states local confinement solely because it is a 1-year term. Only offenses that carry a sentence of more than 1 year, 1 year and 1 day, will receive a commit to the commissioner disposition. The imposed duration changed this felony level conviction to a gross misdemeanor for criminal history because 365 days fits within the gross misdemeanor parameters. Going forward, this offense will be included in the misdemeanor gross misdemeanor section of criminal history until it is decayed under those policies. When an offender receives a stay of imposition, the court will record a finding of guilt, but there will be no imposed duration that corresponds to the durations outlined in 609.02. Although there may be conditional jail time imposed as well as a probation term, neither of those can be used to determine the level of sentence, since there is no corresponding statute to 609.02 that exists to define the minimum term imposed for probation or other sanctions. To determine the level of sentence for a stay of imposition, use the conviction level of the offense. even though that level will be reduced upon successful completion of probation. That reduction occurs only for non-criminal purposes. For criminal history, it will remain at the conviction level until it decays under those policies. Here we see a stay of imposition sentence for a threats of violence offense. You can see that the level of sentence indicator on the Mensa screen is a felony and will remain a felony until it is successfully completed in January of 2019. Assuming there is no revocation of this sentence, the offense will become a misdemeanor upon discharge, and the records will be updated. Make certain to look at the original sentence imposed on an offense that has been discharged to ensure that it was, in fact, a felony or gross misdemeanor. Remember that even if the stay of imposition is revoked, it will remain at the conviction offense level, since that is the original sentence recorded by the Commission. One of the main elements of a stay of imposition, stay of execution, or executed sentence is that there will be a finding on the record that the defendant committed the offense. This makes the imposition, whether it's stayed or not, possible because there is a conviction. In the event of a stay of adjudication or a continuance for dismissal, the offender may enter a guilty plea, but the court will not enter a finding of guilt on the record. This means that there is no conviction. This is why the non-official term for these types of sentences is non-conviction disposition, as this helps to differentiate these from those that do have a conviction. Now, without a conviction, there can be no sentence imposed or stayed. So unless the non-conviction disposition is revoked before sentencing on the new offense, it will not be used in criminal history. Just as a side note here, one of the more difficult aspects of the guidelines can be the exceptions to the rule policies. So just a heads up that there will be an exception regarding these kinds of dispositions when custody status is covered. Here you can see that there is no court decision entered. It says continued. If you were to click back to the other slides, you would see under court decision either sentenced or stay of imposition. So this is the indicator that there was no conviction or sentence imposed, and this type of offense would not be listed in felony, misdemeanor, or gross misdemeanor criminal history. Module 5 will cover criminal history calculation in this training. This section will go over the 4 components that are used to make the horizontal axis on the applicable grid. And those are custody, juvenile, misdemeanor, and gross misdemeanor, and felony priors. Criminal history is calculated from 4 different components: custody, felony, targeted misdemeanor and non-traffic gross misdemeanor offenses, and juvenile offenses. You'll notice that the policy numbers are presented out of order, and there's a good reason for that. The application of a custody point is based on the date of offense. All of the rest of criminal history is based on the sentencing date of the current offense. Now let's dig deeper into these 4 policies so that we understand calculating criminal history. Before we get started, the term targeted misdemeanors will appear in a couple of places, so let's define it. For offenses committed on or after August 1st of 2010, only 7 offenses are eligible to be used as misdemeanors for criminal history calculation. These are known as targeted misdemeanors, and they include these 7 offenses. When looking at custody status, we want to think about three things. First of all, were they on custody for an adult level offense? Because juvenile offenses are not eligible. Were they under the eligible custody status when they committed the current offense? Because it's the date of the offense that counts for this criminal history point. And then finally, what was the type of offense or the level of sentence of the prior offense for the custody? So was it a felony, an extended jurisdiction juvenile known as EJJ? Was it a non-traffic gross misdemeanor? Now this means that driving offenses such as driving after cancellation are not eligible, those types of traffic offenses. But the Commission has said that DWI or refusal to test or gross misdemeanor reckless driving are eligible offenses. And finally, a targeted misdemeanor is also an eligible type. So now that we've talked about when to assign a point, let's talk about the types of statuses that could be assigned for that point. And probably the most common form of custody that you encounter is probation. This is appropriate when the current offense is committed while the offender is on probation for an eligible offense under a stay of execution or a stay of imposition. Now, additionally, we also assign this custody status if the offender is under a stay of adjudication for a 152.18 disposition. This is a stay of adjudication that's given only to drug offenses. So only for drug offenses can you assign this non-conviction disposition as a custody point. And this was one when we were going over non-conviction dispositions that I talked about the exceptions. So this would be an exception to that rule that they're not used in criminal history. They are only used for a 152.18 assigning a custody status point. Although the 152.18 is given for drug offenses, the custody can be applied to any current felony that was committed while they're under supervision. As practitioners begin to navigate the guidelines, the understanding of what doesn't count is often as important as what does count for criminal history. As you can see from the list, there are several situations that will not qualify for custody, and I'd like to highlight just a couple of them. First of all, there is no custody status at all, probation or any other type, for juvenile offenses. One good way to make certain that you're adding a custody point correctly is to check what section you are putting the offense that the custody is related to. Are you putting that offense in juvenile history, misdemeanor, gross misdemeanor, or felony history? And if the only place that you're putting criminal history is in the juvenile section, then there is no eligible custody point rather. Now the offender may be on juvenile probation, but if you'll remember the first slide from this section, it stated that prior offenses must be at the adult level under the guidelines to qualify for a custody point. Now, the other thing to remember as you move through the custody section is that although a particular type of custody may not be eligible, that doesn't mean the offender has no custody type. So this is true when the offender is on probation for a stayed sentence, but they're in conditional confinement status. So they're in jail and they commit a new offense. Probation wouldn't be assigned to that offense, but we are going to talk about what type of custody would be assigned. So what this does is bring up a really important point here, is that although ultimately offenders will only have, in most cases, 1 point, assigning the right type of custody will have implications down the road, such as presumptive consecutive sentencing eligibility, which we're definitely not going to get into here. But it starts with the assigning of the right custody status type. So the next status we'll examine is confined. All eligible custody status types are going to have one important thing in common. They will only be eligible for consideration if there has been a guilty plea, a guilty verdict, a conviction, or an imposed sentence. One of those four prerequisites must be present when confined is selected as the custody status. So first we can see that confined can be assigned if the offender has entered a guilty plea, a guilty verdict, or a conviction. So let's go straight to an example to talk about how this works. So the offender enters a guilty plea for an eligible offense. Here we're going to call it a violation of a no contact order, since that can be at a misdemeanor, gross misdemeanor, or felony level. It's an eligible it's an eligible level of sentence. Next, the offender is returned to jail to await sentencing. Once they get back to jail, they contact the victim that they're not supposed to have any contact with, thus committing a new violation of a no contact order, which will now give them a felony level offense. When the worksheet is completed on the new felony violation of no contact order, the custody status assigned will be confined, since they were in jail when the current offense was committed. The next way that we can assign confined as a status is when they are confined in jail following the imposition of a stayed sentence during the conditional jail time as part of the terms of probation. So this is where we said they commit the offense while they're on probation, but in fact they're actually confined as an element of probation. So they're still going to get the custody status type. It's just that confined is the more appropriate type in this situation. And then finally, confined in jail or confined at a Minnesota correctional facility following an executed sentence. So this is during the 2/3 term of imprisonment portion of the sentence, or when they're in jail during the full sentence and they commit a new offense, then confined is also the appropriate status type. So as we said on the previous slide, all eligible custody status types have that one important thing in common. They're only eligible if there's been a guilty plea, a guilty verdict, a conviction, or an imposed sentence. So that means an offender confined awaiting trial or awaiting to enter a plea is not eligible for a custody status as confined. Additionally, under confinement for a Rule 20 exam is not eligible. And again, we can't emphasize this enough. There is no custody for any kind of juvenile offense. Even in this case, if they were confined in Red Wing, that would not be an eligible custody status type if it was for a juvenile offense. Once an offender has completed the minimum 2/3 portion of the sentence and begins their supervised release term, any offense committed during that time will receive a custody status of supervised release. Now, for certain offenses like felony DWI, an extended period of supervision known as conditional release will begin. It will start when they come out from their term of imprisonment and begin supervised release. And then once supervised release is done, it changes over to conditional release. But again, double check your work and make certain that assigning conditional release is correct. Make certain you have a corresponding offense in criminal history, such as felony DWI or criminal sexual conduct, to ensure that conditional release is the correct status. Conditional release is often applied incorrectly to an offender that has been released pending sentence on a new offense who then commits another offense. It is assigned because the offender has been given conditions on their release. But that is not the same as conditional release. Remember, conditional release is only applied when there is a corresponding offense in felony criminal history. So in this situation, release pending sentencing might be the correct status. But there are still 3 of the 4 prerequisites that must be present to assign this custody status, and that is the guilty plea, guilty verdict, or conviction. An offender may make a first appearance on an offense and be released without entering a plea. And there may be conditions tied to that release, but that is not the same thing. So as you can see by this example, it's important to determine the order of events. If the date of the new offense you're completing the worksheet for falls after the date of a guilty plea, guilty verdict, or conviction on an eligible offense, then release pending sentencing will be the custody status assigned. So here we have an offender that entered a guilty plea or they were found guilty for a qualifying offense on October 7th of 2016. They were released to return on December 15th for sentencing, but during that release period on November 22nd, they committed a new offense. That new theft offense that they committed is the one that will receive the release pending sentence custody status based on this plea that was entered on October 7th. Sometimes an offender will be discharged early from the full duration of probation imposed by the sentencing court for a stay of execution or stay of imposition. When that occurs, the Commission requires that the offender be held responsible for the full duration imposed by the court. Any offense committed after discharge but before expiration of the original term will result in a custody status of within original probation period. Here again, you want to follow the order of events and see where the current offense falls with respect to the discharge date and the expiration date. If, however, the original offense was revoked as opposed to being discharged, then do not assign this as a custody status. So here in June of 2013, the offender received an 18-month sentence stayed for 5 years, set to expire June 17th of 2018. On June 17th of 2016, they were discharged early with 2 years remaining on the original probation term. When this offender commits a new felony on October 1st of 2016, they will be eligible for the within original probation term period custody status because they committed it before the burglary was due to fully expire. So again, they were discharged early, but they remain eligible until 2018. Now, if we hop back up to this bullet point, and the offender is not discharged early, but rather is revoked, and their 18-month sentence is imposed, and let's say they have 12 months of jail credit, and so they do 6 months and then they get out and they're done, and then they turn around and later commit a new offense after the revocation of this original sentence, there will not be a custody status point of within original probation period because there was a revocation of the original sentence. So really be careful and watch for whether or not there was a revocation or a violation and a discharge of the original sentence. An extended jurisdiction juvenile, or EJJ, sentence means that the defendant is adjudicated in juvenile court and given the adult sentence found on the applicable grid based on the severity level and criminal history score of that offense. But that sentence is not imposed unless the EJJ is revoked. The offender will remain under EJJ until the age of 21, at which time it will be dismissed, again provided it is not revoked. If the current adult felony is committed under the following conditions, an EJJ custody status would be assigned. So first of all, the defendant has a prior EJJ sentence that has not been revoked, and two, the defendant is under the age of 21 when the current offense is committed. So their current adult offense, they would get the custody status. Now again, another good way to check your work is based on where you are using the prior offense connected to the criminal history, connected to the custody status. If you are only using juvenile priors, then either the custody status is not valid, or you may be using the prior in the wrong section of criminal history. And we're going to talk soon about where EJJ offenses go in criminal history. So just remember, up to the age of 21 with a prior EJJ will get this custody point. In most cases, an offender is only going to receive one custody status point, but in some cases, an additional point can be assigned. So, first thing we want to look at is the current offense. Is that going to be sentenced off of the sex offender grid at severity level A through G? Severity level H for failure to register does not qualify. Second of all, are they on custody for an offense that equates to a severity level A through G? Again, failure to register doesn't qualify at severity level H. So here's a tip for this. First of all, give the offender the first custody status point, because that may not even come from a criminal sexual conduct or other type of offense found on the sex offender grid, or it may come for a failure to register. They're still going to qualify for that first point. This is for the second or additional point. So here, an example of this would be they're released following a guilty plea for a criminal sexual conduct in the 4th degree at severity level F. While awaiting sentencing on that offense, they commit a possession of pornography offense at severity level G. When the offender is sentenced on the possession of pornography case, they would be assigned one custody point, release pending sentencing, for the CSC 4 that they had entered the guilty plea on. That's because they entered the guilty plea before committing the before committing the pornography offense. Next, they will be assigned an additional point because the offense that you are assigning custody for is found on the sex offender grid at severity level A through G. And the offense that they were pending sentencing for was also at an A through G. So again, just remember to assign the first point and then move on and see if they qualify for the second point. Because remember, you can't give a second point without a first point. Let's just take a minute and recap under what circumstances a custody status point will not be assigned. Confinement for any kind of treatment or exam under a Rule 20 doesn't count. If the current offense occurred on or after August 1st of 2010 and the custody status thereunder is for a misdemeanor, but that misdemeanor is not found on the targeted misdemeanor list, it will not count. If they are under custody related to a juvenile offense, non-EJJ juvenile offenses, it won't count. And then finally, custody for a misdemeanor or gross misdemeanor DWI committed by a 16 or 17-year-old. And in fact, you can just cross any of those offenses off your criminal history list because they're not going to be used anywhere in criminal history. So now that we're done with custody status, let's move to juveniles. When calculating juvenile criminal history, two very important dates come into play. And the first date is what is the date the offender turns 25? Because only if the current felony is committed before the age of 25 can juvenile history be considered. The other date is the date the offender turns 14, because only offenses committed after the offender turns 14 are considered eligible juvenile priors. So once those age parameters are met, then we move on to offense type. And only felony level offenses which are adjudicated delinquent in juvenile court will be used in criminal history. It will take two of those priors types to make 1 point. However, you are going to list all eligible priors on the worksheet. Now, there is an exception to the 1 point rule for juveniles, but here's the advice from MSGC. If you think you might have an offender who qualifies for more than 1 point, please contact our office to review the priors under the policy found in Section 2B, 4B. It's very specific to what can be used to make additional points, and we don't want to get the policies surrounding the first point, we don't want those to get lost in talking about subsequent points. So look at the policy in 2B, 4B, and give us a call if you think your offender qualifies for more than 1 juvenile point. Before we go over the policies for misdemeanors and gross misdemeanors, it's important to remember the policy of using the guidelines in effect when the current offense occurs. That's because we're going to go over the policy that went into effect on August 1st of 2010. Any offense which occurred before that date will have a different set of policies to follow. So when the current offense occurred on or after August 1st of 2010, you can include in criminal history all offenses which have received an imposed sentence or a stay of imposition prior to sentencing on the current offense, which have not decayed. The decay factor for all eligible misdemeanor and gross misdemeanor offenses is 10 years from the date of discharge or expiration, whichever comes first, to the date the current offense occurs. What you want to include in criminal history are all non-traffic gross misdemeanors, gross misdemeanor DWI, refusal to test, or reckless driving, all offenses from the targeted misdemeanor list, and all felony offenses which were sentenced to less than a year and a day. What you don't want to include, again, are those DWIs committed by 16 and 17-year-olds, which are either misdemeanors or gross misdemeanors. Now, This is the section of criminal history that you place the felony offenses sentenced as misdemeanors or gross misdemeanors. Those offenses don't have to be on the targeted misdemeanor list to include them. But if a gross misdemeanor is sentenced as a misdemeanor, that one must be on the targeted list. So, for example, a felony theft offense sentenced to a stay of execution for 60 days, stayed for 1 year, the level of sentence is a misdemeanor because there is an imposed duration which can be found in 60902. This offense is eligible to be used because it is a felony sentenced to less than a year and a day, even though theft is not on the targeted misdemeanor list. A gross misdemeanor theft offense, given an imposed sentence of 45 days local jail, the level of sentence is a misdemeanor because there is an imposed duration which can be found in MnStat 609.02. This offense is not eligible to be used because it is not found on the list of targeted misdemeanors. So the bottom line here, be very careful about the gross misdemeanors that you're using and verify that they did in fact receive a gross misdemeanor level sentence. The decay date, again, 10 years from the date of discharge or expiration, whichever comes first, to the date the current offense occurred. Now, it's going to take 4 units, each prior is worth 1 unit, and it's going to take 4 units to make 1 point, which is the maximum in most cases. You are again going to list all eligible priors on the worksheet. The only way that an offender can receive more than 1 point is if the current offense is a felony DWI or a criminal vehicular operation, and the additional points come from only misdemeanor and gross misdemeanor DWIs or criminal vehicular operations. So if you run into that situation, which can be very rare as we move farther and farther away from the date that felony DWI went into effect, which was August of 2002, we're seeing these offenses drop off and decayed. But if your current offense is a DWI or a criminal vehicular operation, and the offender has an exceptional number of DWIs or gross misdemeanor CVOs in their criminal history, again, go ahead and give us a call, just like you would with the juvenile offenses, because we don't want to lose the concept of assigning the first point by getting into situations that may not occur very often with subsequent points. Felony priors are very straightforward with what will count. And in felony priors, we want to include in criminal history all offenses which have received an imposed sentence or stay of imposition and are not decayed. This is also the section where extended jurisdiction juvenile or EJJ convictions are going to be placed. And they're going to be included in this section even if the EJJ is not revoked. So once an EJJ disposition is imposed, it remains that until it decays. And the decay factor for felonies is 15 years from the date of discharge or expiration of the prior to the date the current offense was committed. Now, prior offenses are going to be worth a half a point up to 3 points, depending on what the prior offense is and what the current felony offense is. So let's go over some tips for looking at those. Finding criminal history calculation for felonies, I find is an easier if you break it into a 3-step process. So the first step would be using the guidelines in effect when the current offense occurs to find the severity level currently assigned to the prior offenses, because it's that severity level that's going to translate over to weights. Now, there may be some exceptions. So step 2 is looking for the exceptions. And the exception here is that the severity level may have changed since it was originally sentenced to the book that you're using to find the current severity level. So a couple of examples for that, and then one big change. First of all, prior sex offenses that are now on the sex offender grid may have originally been sentenced off of the standard grid, so before the sex offender grid ever came into effect. So you might have a criminal sexual conduct first degree that was sentenced in 2000 at a severity level 8. Well, now a criminal sexual conduct in the first degree is a severity level A. So that would be the severity level that you would use to then find the points. Monetary thresholds can be a little tricky because we emphasize using the guidelines in effect when the current offense occurs to find the prior weights, but what happened with monetary thresholds for theft and theft-related offenses, and this is again why it would be a good idea to tab that page in the guidelines. Well, those changed in 2007, but it wasn't a change by the commission to severity levels. It was a change by the legislature to thresholds. And so for inflation. So what they said was over 500 became over 1,000, and over 2,500 became over 5,000. But in theory, the offense didn't change, just the value of the property for inflation. So the commission said we're not going to change the severity levels. So what you do if you have a pre-2000 theft or theft-related offense is you want to carry that severity level straight forward. Severity level 3, carry it straight over because it's saying it's the equivalent of that offense. And then finally, this is the policy change that took place November 17th of 2016. And the commission felt that the method for calculating controlled substance offenses was incorrect, and so they changed it to say that rather than trying to figure out what the drug was, figure out what the amount was for Minnesota offenses, and then change it based on the new thresholds that went into effect August 1st, that the controlled substance offense severity levels are carried forward at the same point value that they had before. Now, they may be a different severity level. A controlled substance 5th degree was a severity level 2 worth a half a point. Well, now it's a severity level D2 worth a half a point. So you might have to make a severity level adjustment, but it's based on what the drug was. It's based on what the degree was that was sentenced. So if it was a 3rd degree, it comes straight across as a 3rd degree. It doesn't matter what the drug or the amount was, as long as it was a Minnesota offense. And then finally, step 3 is you're going to use the points assigned that correspond to the severity level found on the grid in effect for the current offense. So you're using either the standard grid, the sex offense grid, or the drug offender grid. So if you're using the drug offender grid or the standard sentencing grid, then these are the points that you're going to assign to the severity levels. And a really good tip for knowing which weighting scale to use is look at the severity level that you're assigning. Are you assigning a severity level 1 through 12 or severity level D1 through D9? That means you're using the standard grid or the drug offender grid. And so you just assign the severity level and then assign the points that correspond to it. So like we said, if we had a 3rd degree controlled substance from 2011, well, that used to be a severity level 6. Well, now that's a severity level D6. And so the D6 is what we would put down, even though it would also be worth 1.5 points. If your current offense is found on the sex offender grid, that means you're assigning a severity level A through H to the current offense, which means you're going to see a different point value for prior sex offenses. So be particularly aware of how those might adjust. We're going to go directly into criminal history calculation for non-Minnesota offenses while our criminal history calculation for Minnesota offenses is still fresh. And that's because nothing's going to change. There are a couple of exceptions, but for the most part, everything is the same. And by everything is the same, I mean that when determining whether or not to use a non-Minnesota prior in criminal history, the same rules apply as they would to Minnesota offenses. So it's a Minnesota offense, it's a non-Minnesota offense, we follow the same rules. Specifically, it has to be an eligible offense under guidelines policies that were in effect when the current offense occurred to be used, and it must have received an imposed sentence or a sentence similar to a Minnesota stay of imposition before sentencing on the current offense. So let's break down some of the differences, but show you how the rules in effect for applying criminal history in Minnesota apply to non-Minnesota offenses just as well. So let's get all of these points up on the screen. So as stated on the previous slide, and we really cannot emphasize this enough, non-Minnesota priors must equate to a Minnesota offense and an imposed sentence to be used. So if that's not possible because of a lack of information or other factors that may be at play, it will be up to the Minnesota Sentencing Court to determine if and how that offense will be used. And until that is done, the offense should not be listed in criminal history on the sentencing worksheet. So this may make working with non-Minnesota offenses seem daunting, but if you just remember that all of the policies used to determine a Minnesota prior is eligible are also used the same way for a non-Minnesota prior. There are no either or in these situations, meaning it's not either the sentence or the definition of the offense, it's both. And although some non-Minnesota offenses receive 1 year as a felony level sentence, that's a gross misdemeanor in Minnesota, which means that even though it may be defined in statute as a Minnesota felony, it will be used as a gross misdemeanor level unit. Remember the example that we used in the level of sentence about how a felony threats of violence received a 6-month sentence and was used in the gross misdemeanor criminal history section going forward? That's the same concept that we do with a non-Minnesota offense. What can be different is a non-Minnesota felony equating to a misdemeanor or gross misdemeanor level offense. Even though it's defined as a felony and received more than a year as an imposed sentence in the other jurisdiction, it does not equate to a Minnesota felony. A good example of this is a DWI offense. Some states have the second or third offense as the felony, but in Minnesota, it's the fourth in 10. That means that even though it is defined as a felony in the other jurisdiction, it can only be used as a misdemeanor or gross misdemeanor unit on Minnesota criminal history. In addition to the statutory definition, and imposed sentence, If the Minnesota felony being sentenced occurred on or before July 31st of 2010, only the misdemeanors and gross misdemeanors found on the list of eligible offenses in each of the guidelines manuals is eligible to be used. This list is entitled Misdemeanor and Gross Misdemeanor Offense List. This is very different from offenses eligible after August 1st of 2010. And another good reason why you want to keep the guidelines website bookmarked. An example here would be a misdemeanor or gross misdemeanor DWI offense. Before August 1st of 2010, those offenses were only eligible for felony DWI or criminal vehicular operation offenses. After August 1st of 2010, they can be used for any current type of offense. Non-Minnesota juvenile offenses can be tricky, but keep in mind one component of the policy: adjudicated delinquent in juvenile court. That means that if the felony offense was sentenced in adult court, but the juvenile was not certified as an adult, the Minnesota Sentencing Court must determine if the offense can be used in criminal history. Until that occurs, those should not be included in criminal history. When an offender has a federal offense, the first thing to do is determine if there is a Minnesota equivalent and use the prior in that manner. If there is not, the offense will be assigned 1 point in felony history. A good example of this is when the offender is convicted of returning to the U.S. after deportation and they are given a felony level sentence as punishment. There is no Minnesota equivalent of that offense, so the offense would receive 1 point in felony history. Although Minnesota Sentencing Guidelines staff is here to assist you, we cannot make the final determination as to how to use an offense in criminal history. We can only help you use the tools that we have to determine if something is eligible or not. But if something is unclear or it's just not, you don't have enough good information, the Minnesota Sentencing Court must make the final determination for its use in criminal history. Technology has been a great help in finding the statute for the non-Minnesota offenses you're dealing with. For example, if you typed South Dakota felony DUI statute into Google, several website options are returned. You'll want to select the one that ends in .gov, as that is usually a government website with information on it you can trust. Try typing that in and select the DUI facts, South Dakota Department of Public Safety Enforcement. If you scroll down on the page where there is a header entitled, "What is the penalty for driving under the influence?" it will spell out the offense. You'll see that the third offense is the felony, which means it can only be included as a misdemeanor or gross misdemeanor unit, since Minnesota requires the felony to be their fourth in 10. To determine Minnesota statute, use the Revisor of Statutes website, where you can do a keyword search or a search by statute number. The current year will always come up first, but you can change that by adding the year in front. For example, to find the DWI laws from 2013, type in 2013 space 169A.20 for the conviction, or 2013 space 169A.24 for the penalty. There are several other options for searching non-Minnesota offenses which can be found on the MSGC website. Just remember, never guess or assume how to use something in criminal history. If it is unclear, don't put the offense in criminal history. Have the Minnesota Sentencing Court make the final determination. The referenced websites along with the non-Minnesota examples, can be found on the MSGC website under Guidelines Assistance. Select the Criminal History Calculation option and then the Non-Minnesota tab. The Minnesota Sentencing Guidelines website is mn.gov/sentencing-guidelines. Our final module will cover finding the presumptive guidelines sentence. When determining the presumptive sentence, use the applicable grid for the offense being sentenced. Here we are showing the standard sentencing grid, but all of the grids work in the identical manner. For this example, a severity level 5 offense with a criminal history score of 4 has been selected. The grid indicates the presumptive sentence is a commit for 38 months with a lower range of 33 months and an upper range of 45 months. Any sentence less than 33 months or more than 45 months will result in a departure. If the sentence is stayed, that will also be a departure. The lesser or greater length of the sentence will be a durational departure. The change in stay or commit will be a dispositional departure. The worksheet submitted to MSGC should always reflect the presumptive sentence from the applicable grid or the mandatory minimum sentence, whichever is longer. If there is a plea agreement or a sentence imposed by the court that is different from the grid, that could be indicated as a comment. The last column on the grids, all of them, shows the statement 6 or more. This is referring to the custody status enhancement. This policy applies to the or more part of that statement. When the offender has a minimum of 6 criminal history points from juvenile, misdemeanor, gross misdemeanor, or felony priors, plus a custody point for a total of 7 or more, 3 months will be added to the presumptive sentence as well as the range. It may be easier to think of the policy in this manner as well. When the offender has a total criminal history score, including a custody status point of 7 or more, 3 months will be added to the presumptive sentence as well as the range. Regardless of how high the criminal history score goes, the 3 months is only added on one time. Remember, the name of this policy is the custody status enhancement, which means no custody point, no enhancement. The custody status enhancement works for all of the grids the same way. Here again we have a severity level of 5 with a criminal history score of 6. The grid indicates the presumptive sentence is a commit for 48 months with a lower range of 41 and an upper range of 57. Now, if the criminal history score were 7 or more and that included a custody point, the presumptive sentence would be a commit for 51 months with a lower range of 44 and an upper of 60. Please be aware of any statutory maximums when determining whether or not the 3-month enhancement is appropriate. Thank you so much for joining us today on this new practitioner webinar recording. Should you have any questions, please don't hesitate to call us at 651-296-0144 or email us at sentencing.guidelines@state.mn.us. And finally, we do encourage you to bookmark our website, which is mn.gov/sentencing-guidelines.